Welcome to this webinar presented by the It's My Choice project from the Barbara Schleifer Commemorative Clinic. The It's My Choice project is funded by the Department of Justice Canada. This webinar is one in a series that gives basic information about areas of law that may be helpful for survivors of gender-based violence. This webinar will focus on spousal sponsorship breakdowns. The information in this webinar is current as of February 19th, 2026. Please note that this webinar is designed to provide legal information and does not give legal advice about any specific situations. If you or someone you know has specific legal questions, it is best to consult with a lawyer. If you need help finding a lawyer, you can contact your local legal aid clinic or the Barbara Schleifer Commemorative Clinic. Let's begin the webinar. First, let's start with a few important terms. In the context of a spousal sponsorship, a sponsor is a Canadian citizen or permanent resident who is sponsoring their spouse, common law partner, or conjugal partner. A sponsored person, or the applicant, is the foreign national spouse, common law partner, or conjugal partner who is being sponsored for permanent residence in Canada. Both sponsors and applicants must meet certain eligibility criteria for a spousal sponsorship, which are not covered by this presentation. Immigration, Refugees, and Citizenship Canada is a federal government department broadly responsible for setting immigration and refugee policy for the Government of Canada. On an individual scale, IRCC is also responsible for making decisions on various immigration applications, including spousal sponsorship applications. A spousal sponsorship is an application where a Canadian citizen or permanent resident sponsors their spouse, common law partner, or conjugal partner for permanent residence in Canada. These applications can be made from within Canada, known as inland applications, where the sponsored applicant resides in Canada with the sponsor, or from outside Canada, where the sponsored person resides abroad. Both the sponsor and the sponsored applicant must show IRCC that their relationship is genuine and not entered into primarily for immigration reasons. Spousal sponsorship applications also come with a sponsorship undertaking. This is a legally binding agreement signed by the sponsor in which the sponsor agrees to give financial support for the basic needs of their spouse for a period of 3 years after their spouse becomes a permanent resident. A spousal sponsorship breakdown usually refers to a situation where the sponsor and sponsored applicant have permanently separated. This could be because their relationship has become abusive, the sponsor is no longer willing or able to continue with the sponsorship, or the sponsor is no longer willing or able to fulfill their duties as a sponsor. A sponsorship breakdown can occur either while the application is processing or after the application has been approved. Both the sponsor and the sponsored person have a duty to inform IRCC of any material changes in their circumstances while their application is processing, such as a change in marital status, divorce, separation, a change in address, or any other important changes. The timing of the sponsorship breakdown is important for determining the sponsored person's next steps. Please note the following information applies to situations where the sponsored person or the sponsored applicant resides inside Canada. If you reside outside Canada and are experiencing a spousal sponsorship breakdown, consult an immigration lawyer about your options. If you experience a spousal sponsorship breakdown before permanent residence is granted, meaning while your spousal sponsorship application is processing and you reside inside Canada, your spousal sponsorship application is unlikely to continue. In most cases, the spousal sponsorship application cannot continue processing if the parties have permanently separated due to family violence or abuse. A sponsor has the right to cancel or withdraw a sponsorship application in process at any time before the sponsored applicant receives permanent resident status, that is, before IRCC makes a final decision on the application. The sponsor can do this at any time by sending a request to IRCC to cancel or withdraw the application. Once the application is withdrawn, the file will be closed, and the sponsored applicant will no longer be eligible for permanent residence through that application. In this circumstance, if the sponsored applicant has valid temporary status in Canada, for example, a work permit or study permit, they must ensure that they continue to meet the conditions of that permit. The individual should also maintain their temporary status by submitting a renewal or extension application wherever applicable. If the sponsored applicant is out of status, meaning they have no legal status in Canada, they may be at risk of deportation when a spousal sponsorship breakdown occurs. Individuals in this position may be eligible to apply for a temporary resident permit, or TRP, for victims of family violence. A TRP for victims of family violence is a discretionary permit that allows individuals experiencing abuse from their spouse or common law partner to obtain temporary status and have time to decide their next steps. An educational presentation on temporary resident permits, or TRPs, for victims of family violence is available on the clinic's website. In both cases, whether the sponsored applicant has valid temporary status or whether they are out of status, they can request IRCC to convert their spousal sponsorship into an application for permanent residence based on humanitarian and compassionate, or H&C, grounds. A humanitarian and compassionate application, or H&C application, is a way to request permanent residence in Canada based on compelling reasons, even if you do not qualify under the standard immigration pathways. However, an H&C application does not provide the applicant with any status in Canada and does not delay or stop removal from Canada. An educational presentation on H&C applications is available on the clinic's website. The sponsored applicant can also explore other immigration pathways, such as express entry. If you experience spousal sponsorship breakdown after your permanent residence is granted, you generally cannot be removed from Canada just for experiencing a sponsorship breakdown. Your permanent resident status will not be affected or revoked, even if the relationship with your sponsor breaks down and you permanently separate. As a permanent resident, your sponsor cannot force you to leave Canada. You have a right to stay in Canada even if your relationship ends. You may keep your permanent resident status and receive social assistance if your sponsor refuses to financially support you. However, permanent resident status can be taken away through specific processes if immigration authorities believe the individual lied or misrepresented to obtain that status, or if the individual has serious criminal convictions. Therefore, your sponsor may still try to put your permanent resident status at risk. The sponsor may allege misrepresentation or marriage fraud and try to convince immigration authorities that the relationship was not genuine in the first place or that it was an immigration marriage. The sponsor may also accuse the sponsored applicant of criminal offenses that, if convicted, would make the sponsored applicant criminally inadmissible to Canada. If you have concerns about such allegations made by your sponsor, consult an immigration lawyer as soon as possible. A sponsorship undertaking is an agreement between the sponsor and the Government of Canada that a sponsor must sign when applying for the spousal sponsorship. A sponsor must promise to the government that their sponsored applicant, who is their spouse, common law partner, or conjugal partner, will not need to apply for social assistance. If the sponsored person receives social assistance, the sponsor will then have to pay that money back to the government. The sponsorship undertaking lasts for a period of 3 years for spouses, common law partners, or conjugal partners. It begins when the sponsored applicant becomes a permanent resident. This is called the undertaking period. Once the sponsored applicant becomes a permanent resident, there is no way for the sponsor to cancel or shorten the undertaking period of 3 years. If sponsorship breakdown occurs after your permanent residence is granted, the sponsor must still fulfill their duties in the legally binding sponsorship undertaking. This means that even as a permanent resident, if you access social assistance, such as Ontario Works or the Ontario Disability Support Program benefits, the sponsor is obligated to pay the total amount of assistance you receive back to the government. The sponsor is required to pay the money back even if the relationship has ended, if they change their job or become unemployed, or the sponsored person, who is a permanent resident, becomes a Canadian citizen. The sponsored person is eligible to apply for social assistance when they leave their sponsor due to family violence or abuse. However, it is important to know that when you receive social assistance within the undertaking period, which is 3 years after becoming a permanent resident, your sponsor will owe that money back to the government. In a sponsorship breakdown situation, the sponsor does not have an automatic right to custody of your children or shared property. These are family law issues. Any disputes between the sponsor and the sponsored person about who will have decision-making responsibility and where children will live, as well as division of property and support payments, must be resolved in family law proceedings. When the relationship breaks down, either the sponsored person or the sponsor can apply to family court to decide these issues. When a relationship breaks down, especially because of abuse, it is a good idea to talk to a family lawyer as soon as possible. In Canada, physical and sexual assault can lead to criminal charges and eventually convictions. A sponsor who receives domestic violence-related criminal convictions may become ineligible to continue being a sponsor under Canada's immigration regulations. This is important because a sponsorship cannot be approved by IRCC if the sponsor becomes convicted of certain domestic violence-related offenses when the sponsorship is in process. Typically, the prohibition period for the sponsor lasts 5 years, starting from the completion of the sponsor's sentence imposed by criminal courts. If the sponsored person is facing criminal charges, they may face criminal inadmissibility. Criminal inadmissibility is very complex and depends on a number of factors, including whether the sponsored person is a foreign national or has already become a permanent resident, and other specific information about the criminal offense with which they are charged and convicted. It is best to consult an immigration lawyer as soon as possible if you are facing criminal charges to understand the collateral immigration consequences and any potential impacts on your immigration status. If either the sponsor or the sponsored person has been charged, it is important to talk to an immigration lawyer as soon as possible to understand the immigration consequences. The Barbara Schleifer Commemorative Clinic offers legal, counseling, and interpretation services to marginalized and racialized populations of women and gender-diverse people who have survived violence. The It's My Choice project aims to increase access to justice by providing fully integrated, trauma-informed, independent legal advice and independent legal representation to women and gender-diverse people who have experienced sexual assault and/or intimate partner violence. For sexual assault survivors, this includes criminal and non-criminal options. For survivors of intimate partner violence, this includes family law, immigration law, and intersections with criminal law. Furthermore, in partnership with community organizations across the province, sexual assault and intimate partner violence survivors will have the option to access these services at satellite or pop-up clinics and on-site at the Schleifer Clinic. Thank you for watching this presentation from the It's My Choice project at the Barbara Schleifer Commemorative Clinic. Please note that the information in this webinar is current as of February 19, 2026. Immigration laws, policies, and requirements may have changed following the recording date of this webinar. If you have questions or would like to speak to a lawyer, you can contact the Barbara Schleifer Commemorative Clinic at our website or at 416-323-9149. Thank you.